Brody Mitchell Hall.
Hey everybody, I'll start off by saying hi to everyone. We'll start American Courts live. We'll actually even put the camera in focus. All right. We got Judge McNally, we got Judge West, and we've got people in court with Judge Stevens. So we got people in court video we're going to do tonight. But we're going to start off with Judge McNally. He had a fun day today. So we're going to jump into there. Here's Judge McNally.
25R51407. Your name?
Brody Mitchell Hall.
You're going to plead to 80 to 70, right?
Yes, sir.
It's a 1-point violation. You understand that?
I understand.
To the charge of 80 to 70, how do you plead responsible or not responsible?
Responsible.
Why would you be driving on 115?
No reason. I don't have a reason. It was the first nice day I was driving back from Ohio with somebody. So I didn't realize I was going that fast, but I don't know.
Fast you think you were going?
I knew I was going over 70, but I didn't realize I was going that much over. No, I understand completely. I was in the ball.
You know it's different. You knew you were driving over 70, but you didn't have any idea you were driving over 100. I got news for you. You were a lot closer to 100 than you were 70.
I agree.
Why are you doing that?
I have no reason.
210. Please accept it. The original charge dismissed. Son, slow down before you kill yourself or somebody else. Good luck, guy. You're gonna mark up your face.
I understand.
What are you? 21?
20.
Slow. Good luck.
Going nowhere fast. I understand.
I just want to have you come up and tell me their name if you would, and then I can get you out. You can right over there at that microphone, ma'am. Your name?
Lauren Weisenstein.
So I read this report, Mr. Gates. Your client's not here?
No, he's not here yet, sir.
Well, I'm not gonna make the victim wait around. That isn't fair to her.
I can try to give him a call, Judge.
Now, you know what? He had an attitude last time, started calling. You know,
Correct.
I don't know why we have to remind people. I'm gonna get her out of here. Defendant failed to appear. Victim's mother here. Bench warrant to issue. 7,500. It's got quite a record, huh?
Yeah,
Quite a record. 7,500%. Ma'am, would you go down and tell them, I want you notified when he's back here?
Okay.
Okay, are you okay?
Yeah.
I got this reduced to disorderly conduct. You go down there and tell her, maybe you can give her your number so you can know.
The Rockford detectives got her information, Judge.
All right,
I think they've been in contact with her several times.
all right, ma'am, you're all set. I'm sorry.
Okay, thank you.
For the record, it's 9:32. The defense since it was 8 scheduled for 8:30 when you neglected the show. Against Alan James McKee. 25R51419. Defendant failed to appear is responsible as charged. Responsible. Failure to appear, default judgment center. Plaintiff against defendant, Marcus Tell, file 11 Fuller, 240-14674A. And it's just an A file. Can you call in? You need somebody over there. It's Beth, so I don't think Beth is in here. Your name?
Mark Stover, Robert Fuller.
Michael A. Carmen, be 73824, and without depending on it.
Okay. You handed up your appearance.
I did.
Where'd you put that to?
He left it down here, Judge.
Oh, okay. Okay. All right, Mr. Carmen. Just give me 1 second. Your client is charged with violation of probation. He has one prior technical violation. And this is essentially 7 more. Failure to refrain from consuming alcohol, failure to submit to sober blows at 8 a.m. on March 28th. Failure to appear for weekly testing on March 31. Failure to submit to a sober blow on April 3rd at 4 p.m. Failure to refrain from consuming alcohol. Testing positive on a sober blow on April 3rd. Failure to submit to a sober blow at 8 p.m. on April 4th. Failure to submit to another sober blow at 12 p.m. on April 5th. So, Mr. Carmen, how is he going to proceed?
Your Honor, count one is gonna be not guilty in part and guilty in part. Count two is.
Hang on a second, let me make sure I understand. What? All I'm gonna deal with on that, I'm not gonna, these all arrives on the same transaction. Is he pleading guilty to submitting a sober blow that was positive on March 22nd of 25?
That portion of it is,
Not guilty?
yes, as for the 8 a.m. blow.
Okay.
And then the fail to submit, the subsequent ones would be guilty.
Okay. Phone, where's the phone? You gotta remove the phone from the building, sir. No, I want it out of the building. What about count two?
That's gonna be not guilty, Your
All
Honor.
right, why don't we just go? Why don't we just have it installed? Your name?
That's going on temporary, Your Honor.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Yes, Your Honor. I'm sorry, can we just confirm to you, people are not guilty on counts one,
Go.
just through all of it?
Yep.
Okay. All right, so taking a look at count one, failed to refrain from consumption and or possession of alcohol. The defendant submitted to sober blow at 8 a.m. on March 22nd, 2025, with a result of 0.079 BAC. Defendant failed to submit to subsequent blows at 8:15 a.m., 8:45 a.m., 9:15 a.m., 9:45 a.m., 10:15 a.m., 10:45 a.m., and 12 p.m. The next blow was at 2:28 p.m. with 0.0 results for BAC. Count two failed to submit to sober blows at 8 a.m. on March 28th. He then failed, count three, failed to submit to weekly chemical testing at DNA at March 31st, 2025 via DNA. Count four, failed to submit to sober blows at 4 p.m. on April 3rd of 2025. Count five, failed to refrain from consumption or possession of alcohol. The defendant submitted to sober blows at 5:02 p.m. on April 3rd with results of 0.072 BAC. Defendant failed to submit to subsequent blows at 5:17 p.m., 5:47 p.m., 6:17 p.m., 6:47 p.m., 7:17 p.m., and 7:47 p.m. Next blow was at 8:07 p.m. with 0.0 results for BAC. Count six failed to submit to sober blows at 8 p.m. on April 4th, 2025. Count seven failed to submit to sober blows at 12 p.m. on April 5th, 2025.
Do you have any questions over Mr. Kerman?
I would ask with regard to the 3/22, the 8 a.m. on 3/22. That was a Saturday, I believe. If there was a positive blow, does the sober prompt him for a reblow at a certain time?
Correct. Anytime there's a positive test on a sober device, it'll always prompt you for a retest, and it'll continue to prompt you for a retest up to 10 times until either the device is negative, or if it continues testing, it'll time out after 10 times of positive testing.
And how, and at what intervals?
I believe the intervals, if I take a look at the times, are 30-minute intervals.
Okay, so if he had a positive blow at 8 a.m., it would have prompted him to retest at 8:30.
Correct.
But here it says, still submit to subsequent blows at 8:15, 8:45, and then et cetera in half-hour increments.
Correct. It's generally the half-hour increments on the time for it. Again, we always tell defendants, anytime there is a positive test, always submit to the reblows, because if it is an environmental factor, those reblows will be zeros if it was an environmental factor.
Okay, so then 15 minutes, but it looks like in this case, it wasn't prompted after half hour, it's 15 minutes.
Correct.
Okay, could that be contributed at least in part by environmental factors?
What do you mean by the testing times?
Yeah, for that he was prompted 15 minutes later instead of
I
half
could
hour.
be incorrect about the testing times. The SoberLink device and the SoberTrack have different times on them, so I could be incorrect on the testing times, but it will always re-prompt you up to about 10 times generally.
Okay. So that'd be consistent with him blowing zeros at 228.
Correct.
Okay. And then also, with that day was a Saturday, well, I guess I should save that for my explanation, not really a question. So the questions I have.
Does your client wish to testify?
Marcus.
You talk to your lawyer first.
Yeah.
Yes, I wish to testify.
Raise your right hand. Some swear to affirm the penalties of perjury that the testimony you will give in these proceedings be the truth self you got.
Yes, I do.
Okay, go ahead.
All
I
right.
can ask any questions, Mr. Colonel.
Yeah, so Mr. Fuller, and again, I'm looking at some of the notes you sent me, we've.
Yes.
So you sent me some feedback and addressed 1 through 7, and I'm looking at that right here, okay? So you said, you didn't drink at all on 3/22,
I did not.
correct? But later that Saturday, you were doing the court to work program,
Yes, sir.
as for this case?
Yes.
Okay, so is that why you failed to submit to those subsequent blows?
Yes.
Do you remember about what time you were doing the court work program?
Our program started, the doors opened at 8:15 and I didn't leave until 1:30.
Okay, and what were you doing, in the work program that day?
I was outside doing yard work.
Okay, so you didn't have your SoberLink with you?
My solar link was in my coat, but it was hotter that day, so I didn't wear my coat. And I didn't have my phone or my watch.
But when the work program was over, you submitted to a blow about 228, does that sound right?
Yes, that's the time that I got back to my house.
Okay, have you consumed any alcohol that day,
Oh, I did not.
or the previous night?
No, I did not.
Okay. There's a couple, failed to submit to SoberLink blows, one was on 3/28, March 28th, one was on, April 3rd. And I believe there was another one on April 3rd that it said failed to submit. Were you having any problems with your SoberLink device?
April 3rd, which one was, what day was that?
I don't know offhand.
Well, today's the 17th, so that would have been 2 weeks ago today. From 2 weeks ago.
And what time was the April 3rd one?
That would have been,
Well, we know.
yes, April, yes, 4 p.m. And also March 28th, 8 a.m.
Yeah, the April 3rd one, 4 p.m. I submitted the test. I missed the 4 p.m. and I submitted at 5. That one was my fault. I woke up too late. I was rushing to get to work. I woke up around 4:30 and I submitted at 5.
For some of the other ones, for the other, some that it says failed to submit, were you having any problems with the device?
Yes, on some of the other ones, I did have problems with the device. It would freeze up or be non-responsive. And I did talk to the SoberLink place, and she called me about the payment. She said sometimes it does that, and I just have to wait a few moments and the device will be responsive again.
Okay, so you say the SoberLink place was at house arrest?
Yes.
That's where you got it, right? And you talked to a representative from there?
Yes, she called me about the payment and I spoke to her then about it.
Okay, about the, I guess, recalibrating the device?
Yeah, she didn't tell me, well, yeah, that's what it is, that's what it's called.
Okay, so in instances where that would happen, would you give it some time and then it would work?
Yeah,
Okay. Mr. Foley, in the dates alleged going back to March 22nd, have you drank any alcohol?
no,
Have you been around any environmental factors that could possibly result in a positive?
no,
You ever drink any NyQuil or mouthwash or any of that?
I haven't drank NyQuil in my wash.
Uh, when you're at work, what hours do you work?
I work from 6 p.m. to 5 a.m.
Okay, and has that resulted in you missing any blows?
Yes, sometimes I don't get a break because I'm team leader and I have to work through my break sometimes.
Are you allowed to carry the silver link on your person at work?
No. Yeah, it stays in my locker with my belongings.
And you said you work Monday through Friday, 6 to 5?
Yes.
Okay, as a team leader. That's all the questions I have here.
Any other questions of him?
No, you're.
Any other witnesses?
No, sir?
Any argument?
Just that, especially for court work program, they do allow, all defendants to keep their cell phone device on them for court work program. And again, court work program, he was here on March 22nd for court work program and didn't complete his day here. Again, he did test at 8:30. We require everyone to be here at 8:30. So when he tested at 8 a.m., when he tested and was tested positive, the device would have prompted him and said to retest. So he still would have had time to retest prior to needing to be inside the courthouse for court work program. And again, the court officers will allow the device on them at all times.
Anything else?
No, Your Honor.
Anything else?
Your Honor, I would just like the court to again know that my client does, I mean, he's got a really good job. He's a team leader at the Dearborn Truck Plant, as you can see on his jacket. He recently took in his sister and her 3 young kids living with him. She's here today, as her support. We're asking to give him, I know it's asking a lot, Your Honor, but to give another crack. I mean, he'll be on a very short leash, but any incarceration can result in him losing his job.
Court finds you guilty of all 7 counts. Court finds he was consuming alcohol, which gave rise to the test on March 22nd and 25 with a 2.079, and he failed to submit the subsequent blows. The fact that he's telling me that it was hot and he didn't want it in his coat, he didn't have it, didn't have his coat, and therefore the sober link wasn't with him. That's his fault, not ours, not anybody else's. He also failed to submit to a sober link blow, I find, at 8 a.m. on March 28th. Failed to appear for weekly testing on March 31 with DNA. Failed to submit to a sober link blow at 4 p.m. on April 3. Consumed alcohol, giving rise to positive test on April 3rd of 25, and then he failed to submit, ironically again, to all subsequent blows. And then he failed to, and I say ironically, I mean, it's just pretty obvious what's going on here. And then he failed to submit to a sober link blow at 8 p.m. on April 4, and again at 12 p.m. on April 5/25. Court finds defendant guilty on all counts. I'm more troubled by it. He's just sitting there and he's giving me all these excuses and he's testifying under oath. And that's a problem. That's a massive problem. It is. It's a big problem. Yeah, I'm looking at you.
No, I'm saying, do you want to speak?
No, I don't. I don't think what you incriminate yourself any more than you already have. You can't just come in here and say I didn't drink. And give me all these excuses as to why you didn't blow. If you want, I'll put you on the alcohol test. You won't have to worry about it. Why don't you give them a price differential? Do you remember?
I don't remember off the top of my head.
It's more, right?
I'm sorry.
It's more.
Yes, it is.
Than the other soda.
And it's more per day as well.
Right. You wanna do that? You wanna do an alcohol tether, then you don't have to worry about blowing. You're just gonna keep it on all times.
Judge, for the alcohol tether, it's gonna be $100, or the tether, yes, it's gonna be $100 to roll, and it's $10 per day.
You, is that voice?
Yes, yeah, I'll anything.
Listen. Don't come in here and tell me you want to think. Run the road. Run the road. This is something here. I can forgive mistakes. I can't forgive the sins. I cannot forgive the sins. Why? Under oath. You almost just talked yourself into going to jail. I don't know if I would have done that.
So you gotta take your hat off.
Your Honor, if he's willing to get the tether today, maybe we could schedule this for a sentencing. See how he does with it. If there's any positive readings, the court take that into consideration. Have him increase his AA appearances as well.
Jen, definitely see what anything supposed to do. This section of February 5. You got 7 counts. When he pled guilty, when he was found guilty back on February 27th. Can you tell me what that was for? And I'm talking about probation violation.
So that was for testing positive at DNA center for,
Oh, yeah, the artificial penis.
Yes.
Listen. Section, you give somebody else that job, how much she make?
$36,000.
Oh, but here's the ton of people. I might go over there. Coming up with these stories. And again, you're looking at me like I can't add 19 and 6 without a calculator. Going to rate this. What do you think? I mean, maybe you can go talk to a kindergarten class and you can convince them. I don't know what to tell you. The more I hear on this, the worse it's got. Well, but you clear all of your warrants. You're supposed to do that by March 3rd. Did you do that?
No, I mean, I didn't have.
You know what? I think I should just come over there and you can come with the robe on and you can make your own decisions here. Are you in treatment?
Yes, sir.
It's not helping. What's the strange, still, ulcerative?
That's right.
Shame on me for not sending you to jail for trying to fraud the testing facility. Realize you just committed perjury? I don't want you to answer that. I want you to answer. Do you realize you just committed perjury? I don't want you to answer that. You just committed perjury. You're to pay additional costs of $50. You're to be on a screen tether first day following release from jail. You're to test weekly for 3 months, then bi-weekly. What am I missing? Am I missing anything?
I don't believe so, Your Honor.
You're to serve 7 days jail starting right now. 21 days to appeal, 14 days to apply for a court.
Your Honor, would you consider letting him serve the weekend, next weekend, so he doesn't lose the job, please?
I don't have anything to do with where they sent him. Brownstown doesn't take weekend. I can't do it.
Brownstown doesn't take weekend prisoners.
Lisa, would Brownstown send him to Flat Rock by chance?
They might. I can double check if you want.
Why don't you check and let me know?
Okay, give me a second.
Your Honor, I know we've made similar weekend fake jail
Listen,
arrangements before.
honestly, I should give him extra. Don't push him. The guy he's a liar. Don't push him. Have a seat over there and I'll figure out what I'm gonna do. I don't know that I'm even inclined to let you do weekends even if I can.
We appreciate the court's consideration. Thank you.
Michael Richard Clark Jr. 252 1W28773. Your name?
Mark says, Bono.
Since you paid on 2 Judge Hefson cases, right, or posted bond,
Yeah,
you have the money to pay this.
I can do a payment plan. No, I'm a stay-at-home dad with 2 kids.
Why are you ignoring court like this, sir? This has been going on for 4 years.
I know, I was young and dumb and I was
It's
trying
your
to pay.
it's your words, it's not mine. I mean, come on.
Yeah, well, I wanna pay everything off, so.
When can you start paying?
I can pay some of it today
How
and
much?
then $100.
Pay 100 now.
Yeah, and then, my wife, my girl gets paid like every 2 weeks, cause she's working right now, cause my life,
Can you pay another $75 by May the 2nd?
May the 2nd, yes.
I'll tell you what. you
Wait,
pay-
listen, what day is May the 2nd?
Right,
Friday. Yes, I should be able to pay that.
well, I'll make it May the 5th for you, okay?
Thank you.
You pay 100 now. By May the 5th. I'm gonna reduce your balance. Balance reduced to 200, so I'll save you a few bucks, but you still have to pay the clearance fee, okay?
Okay,
Actually, I'll make it 190. Right, so you're gonna have to pay 100 today, 90 more by May the 5th, and then you still have to pay your clearance fee to get this suspension lifted, okay?
what's for,
$45.
that's it? For the clearance fee?
Yeah, so you're gonna pay 100 today,
145 and
$90 by May the 5th, and you can pay your clearance fee that day, okay?
okay, I'm getting paperwork for all this.
Yeah, she'll give you a printout, go down the hall, I'll give you a printout, okay?
All right, appreciate it.
Stop doing this, will you?
Yeah, I'm trying to get everything taken care of so I can go to South Carolina. Man. So wife got drive the whole way, but
She what?
she got to drive the whole way so I can get this clear.
What, are you moving to South Carolina?
Yeah. This has been nothing for trouble. My dad's getting divorced. My sister and brother don't talk to me, so I was just like, we moved back here like 3 years ago just to see, help people out, and that just went south. It's a bunch of crap. Dennis, right?
Well, I wish you well, good luck.
Thank you,
I
sir.
really do. Best of luck to you. Thank you.
Yep.
All right, so tonight's DUI night, we got Judge West, and then we also have people in court showing a Judge Stevens one. We'll go to the Judge West one, and then we'll go to people in court. The people in court one's got Judge Stephen raising hell, and I always like seeing him. So let's check out Judge West first, and then we'll jump over.
All right, this is cause number 24 DCCR 0122, State of Texas versus Catherine Welch. Ma'am, are you Catherine Welch?
Yes, Your Honor.
And Ms. Welch is here with her attorney, Mr. Gertz. State's attorney is present. Ms. Welch was previously in court, entered a plea of guilty to driving while intoxicated third or more, as well as a prior offense, which made it a second-degree felony offense. There was no agreement with regard to punishment. I have received the pre-sentence report, and has everyone had an opportunity to review that report?
We have, Judge.
Are there any additions or corrections to that report?
Not from the state, other than I want to acknowledge I have received Mr. Gertz's sentencing memorandum as well.
I'm going to get to that too in just a second. Any additions or corrections?
Aside from the one comment that I make in the sentencing memoranda about a comment that she made about rehabilitation, I think it's more of a clarification, so I'm happy to touch on that. But other than that, we don't have any additions or corrections.
Okay. And Ms. Smallfino has already stated, as well as I received the sentencing memorandum at 5:47 p.m. yesterday. Going to point that out for the record.
The Harris County judge got her sentencing memoranda at midnight, so.
Well, it was reviewed quite early this morning, but I did review it. Ms. Smallfino, you've had time to review it as well?
Same here.
Okay. Other than that, I think you all should have a couple, there's only a few, but there were some jail incident reports that should have been provided to council. Did you both receive those as well?
Yes, Judge.
I did.
Okay, is everyone ready to proceed with sentencing then?
Yes, Judge.
Yes.
All right, Mr. Gertz, do you have witnesses?
I'm not going to call any live witnesses unless the court requires it. When we have a person present from the Dream Center, if the court wants to inquire about that, I would essentially let her come up and talk if you want to have that conversation. But
Okay.
I think, our focus here is going to be on the topics that we talked about or write about in the sentencing memo. And, just sort of allowing, if the court decides to do what we're asking you to do, we are open and welcome to whatever the court requires of her
Sure.
to enter and successfully complete. We just wanted you to have that option on the table as well. That
Okay.
is an option that doesn't cost the court anything. Or
Right.
the state anything.
And for the record, I'm aware of the Dream Center and their program and what they do. And so if I have any specific questions, if we get to something where I would need that, then I appreciate them being here and I'll ask those questions. Ms. Malfino, does the state have any witnesses?
No.
All right, then argument.
Judge, I want to, I recognize this is a unique case and a unique ask that we're making here. This is not something small that we're asking for. I have sort of personally taken Catherine on over the last 3+ years, I guess almost 4 years, as a project for me, if that makes any sense. And what I mean by that is I really wanted to put to the test, could this person do everything that I asked her to do to at least get her an opportunity to be here in front of you asking what we're asking for? She exceeded my expectations by doing the 90-day inpatient rehabilitation. And while she was there, she started to explore with her counselors and her therapists there some of the underlying issues that went beyond just physical addiction, but actually had to do with her mental health and some of the things that she's experienced in her life. I'm not going to detail them on the record, but the court is aware of what those things are. Incredibly traumatic events that I think she had repressed and had never really addressed and explored. And so those counselors recommended not just aftercare, but a specific outpatient program to address some of the trauma issues that she's had. She went and checked into that program, stayed for basically a year, and again, did everything we asked her to do. When, I told her to go get her own drug patch, I told her to go get her own interlock device. She did all of that. Those records should be attached to the memo. She was successful, has been following the rules, doing everything we've asked her to do, had been going to AA, had gotten a counselor, actually reached out and befriended the director of the Dream Center to try to figure out what she can do next to sort of commit herself to her sobriety and to fixing the mental health issues that I think stem from the challenges that she faced as a young person. Sometimes it's easy to look at one side of the ledger, the rap sheet or the criminal history, and think that defines this person. What I have been fortunate enough to do is to really dig down and get to understand her as a human, and see that all the progress she's made, all the effort she's made, and see what she's done well and all of the problems that she's been addressing well. She's obviously very anxious about this day, but we've been looking forward to this day as well to be able to present that. And I want to go down on the bottom of page 2, address what I was talking about in the CSI. So that I'm not saying that this wasn't the words that came out of her mouth, but when she was asked by one of the examiners in the probation report, she felt she needed treatment. She said she didn't feel like she needed treatment. She wasn't opposed either. I want to clarify what we mean by that. And I say this here, but what she would say, I think, is she did 90 days of detox rehab related treatment, has continued aftercare, has continued mental health care. But in terms of going to a program that is specifically targeted at people who are currently using or currently intoxicated, I think she thought that wasn't the direction that would be ideal. She will do whatever you want her to do, but I wanted to explain what that comment means. And so, because a lot of times, as you know, Judge, private rehabilitation programs will just reject you if you've been clean for 3+ years, as she has. And so they just won't even accept you at all. So I think that was just a misunderstanding or a miscommunication between the probation officer and Catherine. But nonetheless, she's willing to do whatever the court chooses here. Additionally, we've been in contact with her current parole officer. They are willing to keep her on parole instead of revoking her, depending on what the court does here. And so that was encouraging as well. I think we had the same kinds of conversations with them about her recovery and about her efforts. And so I think that was an encouraging sign from them. And then finally, Judge, you see, we didn't want to focus too much on support from the community because, again, this isn't just a run-of-the-mill case. This is a different focus. But she is married. She has a family. She recognizes the impact that all of this has had on her family and her relationships, the strain it has put on her husband, both financially and also emotionally. And she accepts responsibility for that, and is asking the court to consider this extremely rare position that we're asking the court to take here. And obviously, if the court would like her to address the court, she is happy to do that. Or I'm not sure how you want to proceed on that.
Okay, thank you. Ms. Malfino?
Judge, I don't envy the position that the court is in this morning. I do take very seriously the comments of Mr. Burks. I take him at his word for that, and I hope that all of those things are true. It's difficult for me as a representative of Jefferson County and the state and the citizens that work on the roads every day to stand up and say I agree with probation, but I don't disagree with the things that Mr. Burks has said and the information that is in his sentencing memo. To play the other side of the coin, does it suggest that she received the benefit of the doubt already by me waiving the habitual status that she could have been facing based on her number of priors? Does it seem in good conscience that I can say I ignore all of those priors? Absolutely not. But obviously, we have seen that her multiple trips to the penitentiary have resulted in no change of behavior until hopefully now, in these last 3 years. And I do sympathize with Ms. Welch as an individual. Again, it's hard for me as a district attorney, assistant district attorney, to say that I concur with the punishment being probation, but I don't, again, disagree with the comments that Mr. Gertz has. We've had multiple conversations about this case. I know he's worked very diligently at it. I don't really know, Judge, and that's why it's before you, that putting her in prison for 20 years and her getting out in 2 versus an extensive probation period where she can continue the recovery she's been doing is a better option. But again, I don't know what is in the best interest of public safety. Unfortunately, none of us do. So I would defer to the court's wisdom and whatever you think is appropriate based on the volume of information that you have before you.
All right, thank you. Anything else?
Would you like to say something, Judge?
Your Honor, I just want to say that the past was fueled by drugs and alcohol. I take complete responsibility for that. I did not know from very young when things happened in my life that it could have been, some of it could have been treated and stopped earlier if I had gotten help for my mental health. That after I received this DWI, that helped me get myself to a place that I could go into a treatment program and deal with some of those past traumas. In the past, I didn't. I medicated and drank to just forget about the pain, just numb myself out. I didn't know how else to deal with that until when I got on my mental health meds, and I have bipolar, I have PTSD, and my mind back then was very chaotic. And I just want to say, after I had my mental health meds, I was able to go through treatment at Santa Maria in Houston, and that place really saved my life. I did extensive 90-day treatment with trauma counselors. It was a trauma-informed community there. And also, when I completed that, I worked an outpatient program, but I still lived on their facility. I went to the sex trafficking and recovery program, and I was in that for about 8 months, where I got the state paid for the counseling for trauma still. And I just worked really hard in that. I got a job while I was in there. And then once that program was over, I moved to a sober living facility in Oxford House in Spring, and I worked there until I felt like I was strong enough to come home and do what I needed to do. And I was in the complete program for right out of here. And I'm sorry, I'm very nervous today, and I know that my past record is, like Ryan said, atrocious. But you know, the things that I had to deal with within myself from when I was a little girl, those are things that you don't go to prison, even in their programs there, that you don't talk about. It's just, you just don't. And I'm asking you, please do not send me back to prison. I want to move forward. I have moved forward in my life, and this year that I've been in jail has given me more time to think and know that I am definitely headed in the right direction. I have a sponsor. I attend AA. at home. I had moved on with my life as far as I could with my sobriety. I mean, I knew this charge was out there. And I think I made some really good choices with my Mid-County AA friends. They've helped me a lot, and I am open to anything. I will abide by all the rules and do anything that's asked of me. And I think, I know now that I'm responsible and capable of taking care of my business and my life.
Thank you. So, Ms. Welch, Ms. Malfino probably said it yet best, and I get this often, and they don't envy my position, and this is the worst part of my job. But I worked hard to get here, and it's my job. Part of my job, it's several things, and it's to look at, obviously defendants and giving chances and things like that, but it also is about making our community safe. And I have to look back. This is your 10th DWI. It's not your 5th. It's not your 8th. It's the 10th. And while I understand the trauma that you went through, that you've been to Safe-P 3 times. You've been given opportunities on probation where they were revoked. You've had opportunities while you were on parole to do what you have done now. And while I appreciate what you've done, and I think that's great, and my goal isn't to, to stop any improvement, but I can't, in my opinion, in good faith, go home tonight, look myself in the mirror and say I gave somebody on their 10th DWI, that your last sentence was for 15 years in prison. The one before that was for 10. The one before that, you've gone to another 10 years, back in 09. I mean, this goes back to the 90s. You got a 10-year sentence in 2011. While you're on parole for that one, you get another one, so they give you 15 years, and you get out and you're on parole and you do it again. The fact is, we're just lucky that you haven't killed someone in our community 9 times over, being given opportunities. I just can't do it. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find and your plea of true to the prior offense. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to sentence you to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not, well, I guess there was an agreement because the waiver of the enhancement, which could have been a 25 to life, as Mr. Gertz said. So I'm going to hand you the certification that shows this was an agreement. You've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Possession, because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read the written admonishment I provide you. If you have any questions about that, you can talk to Mr. Gertz. And Ms. Welch, I take no pleasure in this. This is extremely difficult for me. I understand to some extent addiction, and I understand that you are on a better path. However, there have been plenty of opportunities in the past where you were on a better path and you got back out and you got back on our roads again. And so good luck to you, ma'am. Thank you, Mr. Gertz and Ms. Malfino. Court will be adjourned.
All right, so 10 DUIs and she finally got 18 years. I don't know how the Texas court system works. I wonder if she spends 18 years or if she'll spend 8 years, 9 years, 10 years. After a while, she's going to get old enough where she's not going to be back out on the roads driving. And so I guess we're just going to house her until she ages out. I don't know. So I put that poll up because earlier I got a comment on a video that said that all cars should be manufactured with alcohol devices. And my first response is never, no. And then I started thinking about seatbelts. And then I started thinking about what would it really hurt if all cars had it. And then I started thinking about technology, and my son has to wear an ankle monitor that checks for alcohol. And if they're going to come up with some technology like that, figure it out in the steering wheels. Figure it out in the steering wheels. But then the person who does cleaning for a business and uses alcohol in their cleaning, then they can't drive. And so I kind of, at some point, we just got to be responsible. The person's comment was based on just stopping alcohol-related accidents at all costs. And I kind of feel like the answer is you don't let people get to 10 DUIs and still be out on the road. So good for Judge West here. Thank you for everybody participating in the poll. We're going to go to a People in Court video. I put a link to her channel. Make sure to go check it out. Make sure to like it. If you've never seen People in Court, you can just pretend this is my video and never mind her watermarks. Don't acknowledge them, and we can just all pretend that I didn't steal the video. Remember, I didn't steal the video. It's not really a watermark. So here we go over to Judge Stevens in the same building as this judge here. Here we go.
Come on up, please, man.
Yes, sir.
25 CR 144 is called, and you were Shelby Nicole Celerandi.
Yes, sir.
Used to be, when I was growing up, Weaver Celerandi.
That was
Automobiles.
yeah.
That was the big car dealers in the area.
Right.
Weaver Celerandi. Two names, two different people. Okay. Probably got to be related. How many Celerandis are there?
Right.
Got to be related to something.
But I found like
Are you driving a new car?
She's not, she has a DWI.
I know. I was asking.
I have, sir.
Last time she was here, I believe Mr. Kimler had not been hired yet, but he had filed a notice, and she had her bond raised because she threw a drug test in the toilet.
Okay, as you know, you were charged here with a third-degree felony of operating a motor vehicle in a public place while intoxicated. And it's a third-degree felony because you have 2 prior DWI convictions here. I'm sorry. Yeah, there was, well, these were blood alcohol 0.226 and 0.231, which are about 3 times the legal limit. But it wasn't drugs, it was alcohol. You have some kind of a device on, do you have an interlock device on your vehicle?
Yes, sir.
You have to blow in it before you
Yes,
can
sir.
start the car.
That's the thing. So I don't even touch my car.
You don't even operate a car?
No, sir.
Okay. Well, you can do less damage that way.
All
That's
right,
true.
because I'm suspended. So I can't even get in there.
Well, you can't operate any motor vehicle without an interlock device. If that happened, your bond would be revoked and you'd sit it out in jail until we can dispose of this.
Correct.
Because that's too dangerous for others and yourself. You have a drug patch too?
Yes, sir.
You have a drug patch?
Yes, sir.
Okay, as well. That's because you tested positive for cocaine and meth last time, right?
Yes. I just.
I see it's there. I see it.
Yeah, I see it. Okay, how often do you get that changed? You got to change it so that they can test it to see.
Correct.
Or
It was today. It was, I thought,
today they're supposed to do something? They're going to take it off and test it today, and is that what they're going to do?
Yes.
Is that what you're saying?
it's supposed to be yesterday.
But what happened yesterday?
I thought court date was yesterday, but it was 17th and somebody changed it to the 17th.
That was my, that was supposed to be in trial, and so Elliot changed the dates.
That wasn't me.
That was,
She was actually set, I believe, the day before.
Okay, what were you gonna do to her? What did you?
well, with her, just reset it for an announcement. I think today was just a day to make sure she was compliant with the bond, but I need to complete discovery, so we'll just have her set on the morning.
Yeah, it is, it is an announcement there.
Could I have a little bit of time to look at the discovery?
Yeah, you went 4 weeks?
This was.
Okay. But we're gonna test her before she leaves. Even though she's got the badge, I wanna know where she stands right now. Okay, just have a seat right over there. And then, 4 weeks, reset 4 weeks. Thank you. Hey, Brian.
Yes, sir.
Hey, so I'm gonna bring up Sherry's question here. What does the drug patch do? I've heard of drug patches. I just really haven't ever seen what they did, and they're talking about you take it off and get it tested. So, some Allie, I'm sure you've had a drug patch time or two. If you're in the chat, tell us what a drug patch is and what it does and how all that works. I've heard the term before, but I've actually never paid attention to what it did. I just always assume if you don't do drugs, you don't need a drug patch. But somebody has the answer in chat. We can always count on chat for the answer.
Justin Barry. Yeah. 3 cases, right? 3?
Yes, sir.
Yeah, come on up. And
there's some.
yeah, and benzodiazepine. But I mean, I don't know her, but I'm pretty good at what looks normal, and she doesn't look good right now. Not that you're not an unattractive lady, but you look like you're bewildered, and you look like you're intoxicated with something. We see it every day. We know what it looks like. You tested positive for alcohol, which you shouldn't have, and which is what you're in trouble for, among other things, and benzodiazepines, which is a controlled substance. What is your plan?
You have a prescription. Appraisal one?
Yes.
You didn't drive up here, did you?
No, sir, my mom was there.
Did she live with y'all, man?
No.
No. She's free falling. She's free falling.
Her bond's $20,000.
Family needs to help out on that.
All right, so I'm looking up drug patch. It says the drug patch functions as a storage device. Drugs used in 1 to 2 days before the patch is applied, while the patch is worn in up to 24 hours before the removal of the patch are detected and stored in the patch. And so it's a successful and economical way for long-term continuous drug testing. So that's what a drug patch is. And so I've given you no information. So here we go with the rest of the video.
Because I can only put her in jail. I can't I can order help at some time, but where's her times?
Oh, it's right, Sarah, you give it back to me.
She indicated she does have a prescription for appraisal lawyer. Explains the benzos, but of course that alcohol is.
Yes, because it was 3 times the legal limit for alcohol on the offense. What is her bond again?
20,000.
Yeah. All right, your bond is revoked, and it is now doubled to $40,000. That's what happens when you violate the terms and conditions of your bond. You have a drug patch, correct? You have a drug. Yes. Okay. All right. We've got to now do something with the alcohol.
Well, he's here today.
And
I believe it's scram, was it, Your Honor?
what's the best thing for this situation where we got drugs and alcohol?
There you have.
The scram device. Okay. You must have a scram device as well. And that stands for, it's an acronym. But both of those devices are going to be a condition of your bond.
I'm sorry, you said screen device?
Yes, and continue, and she has to have a drug patch as well, which is costly, but something needs to be done to figure out how this is going to end up. Because you're showing up to, you're not only in public, get in trouble operating a motor vehicle, 4,000-pound missile while intoxicated. Now you're showing up in court and you're inebriated, and it's just you got alcohol in your system and drugs in your system, which don't help clear thinking and resolving this. You need to do better, or else it is a catastrophic end. Anyways, those are the findings, and you're taking them to custody. Is Victor Davis here? The bailiffs, you're in custody. The bailiffs are in control, ma'am. You have to follow their orders. Thank you.
All right, I'm going to back it up 30 seconds. There you go. I'm going to back it up just so you can see when you're in court and you're leaning over the table like that, you know that you're not in the right spot. She definitely she messed up. She's going to go get some treatment. Did he say how long she's going to have to go, or they just got her back? Yeah, Allie got in trouble for doing stuff to get the drugs, doing very questionable stuff to get the drugs. And so we're going to just speculate on the ethically questionable things that Allie did to get drugs. And whenever Allie puts out videos on her show, she's going to talk about that type of stuff. And it's going to be super exciting for all of us, and we're all going to love her channel. So, Allie, get to work. We're going to be done for tonight because it's that time. Tomorrow, there's no Judge Fleischer tomorrow. Judge Fleischer is off for Friday before Easter. Good Friday. That may be the holiday. I'm not sure. It's a holiday before Easter. So you guys have a great day. Figure it out for tomorrow. If there's any way at all I can stream, I'll make sure to try to stream. But I have no clue what my day has lined up for tomorrow. So I am certain Law Talk with Mike is going to do something. I know Kathy's going to do something at 4:30. So make sure you're there bright and early at 4:30 in the morning. But we will see you next time.
Please.